Yeah, this is part 2. And then also, it says, it's a judge's duty to consider and pass upon evidence produced before him or her, and when the evidence is in conflict, to resolve that in favor of the party whose evidence outweighs that of the opposing party. Craigling versus Superior Court, 1944. 25 Cal 2D, pages 305 through 312. That's the case law for that. Okay, so when you say all that, when a judge is making a ruling, they're supposed to weigh out the credibility, the evidence, and then make their findings, right? So in my case, where this particular judge that I was trying to have her disqualified for my recent case of workers' comp, she barred a previous case, and she didn't take in consideration this Craigling versus Superior Court, 1944. Because if you're going to interpret evidence and you're going to the credibility, I had all of that. So I'm hearing something. Anyways, I had those things. So why didn't she use the evidence and the credibility and all of those standards then? Because for one, I had my medical excuse. I was always doing my always being available for my hearings, meeting the deadlines, and also when you're pro per, they're supposed to use discretion. They're supposed to look at the case and say, wait a second, how is this fair for the worker? Okay, and you're gonna be fair to the defense as well, but more so, it's like you look at the injured worker, like what happened, and in my case, it was actually I had a medical issue that I had to attend, so I had to take off of this case for a while at that time. So she didn't look at that. I don't believe she took that in consideration, and the fact that I had been dealing with that case for 13 years. 13 years. And what they wanted to do was we're going to show you, Miss Black lady that's coming in here trying to do this on your own, and you don't want to get an attorney. We're going to show you that you're not going to win. We're going to put it to where you don't win. And so that's exactly what they did. They go ahead and give it to the defense and say, well, due to operational law, operational law is like you have 5 years from the date of injury, and this case has been going on for 13, and you dismissed your case without prejudice, Miss Williams, so it's done. Based on operational law, you can't come in and do that, because if you dismissed it and it's after the date of injury, which was back in 2009, at that time it was 2006, I believe, and so or 7, you can't do anything about it now. It's been over the 5 years. However, we've been dealing with this case for 13 years. So how are you going to use operational law? I said to myself, definitely this is wrong. You can't use operational law if the case has been going